moderated by Evan Swarstrober, a senior fellow at the Digital Progress Institute. We have, I think, a really interesting conversation teed up from you all. There will be no questions following this panel, but everyone will stick around, so if you have any, feel free to track them down. Evan, you may head up on stage and welcome our panel, everyone. Thank you.
Just so you all know, this is notes. I'm not sports betting or tweeting or anything. Well, thank you all for joining. The title, of course, is Bottlenecks to Innovation, and there's been a heightened focus among antitrust enforcers and legislators, both here and abroad, of the consolidation of certain inputs to innovation, certain things that innovators need to be successful, whether that's access to smartphone customers, whether that's access to chips, compute, cloud computing, energy. There's a lot of things that innovators need, and when folks look at the ecosystem and see that those inputs are controlled in many cases by a small handful of companies, maybe even one or two companies, those companies have the power to either make those a gateway to innovation, or they can gatekeep those innovations for themselves, make them a bottleneck. So we're going to talk about that today with four great panelists who have a lot of expertise across the tech stack. Starting with my left, Gene Burris is the Global Policy Counsel for the Coalition for App Fairness, which advocates for freedom of choice and fair competition across the mobile app ecosystem. He is also an advisor and spokesman for the Browser Choice Alliance. Prior to those roles, he served as Director of Global Competition Policy at Spotify, and he was Assistant General Counsel at Microsoft. That may come up on the panel. To his left is Taylor Hogendorn, Deputy Director of the Bureau of Competition at the FTC. He was appointed by Chairman Ferguson, who we had the honor of hearing from today, in March 2025. Prior to that, he worked in private practice in Houston and clerked for Supreme Court Justice Samuel Alito, as well as judges on the DC Circuit and Fourth Circuit Court. To his left is Michelle Herman. She is the founder of Just Tech Law, a boutique firm specializing in industry standards, open source software, and IP in emerging tech. Prior to that, she served as a partner at Davis Wright Tremaine and was also an associate general counsel at Microsoft. It seems like all roads lead to Microsoft when it comes to antitrust. And to her left is John Talladay, partner at Baker Botts LLP, where he co-chairs the firm's antitrust practice. He has extensive experience representing clients before the FTC, DOJ, European Commission, and other international agencies. Thank you all for joining. So Gene, I'll start with you because everyone, of course, uses a smartphone, and if you're in the United States, that is invariably a smartphone that uses the Google Android operating system or one that uses the Apple operating system. Your organization, many have pushed to open up the app stores. The developers have griped about 15 to 30% fees of Apple copying their innovation, of getting kicked off the App Store. But at the end of the day, what does it mean for innovation? Why should any consumer really care if a developer has to pay an extra fee or if it takes longer for their app to get approved? You know, what consumers want is innovation. So why should the consumer care about the fact that Apple and Google, have 99% plus market share in mobile operating systems and app stores?
So, I think the main reason is, especially when it comes to digital innovation, those two companies control an essential distribution facility for anyone's digital product. So if you want to reach a consumer, and you're in a digital business, there's two ways, right? Either on a PC, which people are increasingly not using for a lot of what they do, or phones, which have become the way people interact with services on the internet. What it means to innovation, I think, you talked about some of my history at Microsoft. I think I have a little historical perspective on how all of this works and how we really solved this problem once upon a time, 25 years ago, when Microsoft was the sole means of accessing the internet, right? When, you think back to the year 2000, the only way to get on the internet was on a browser on a PC, and that was controlled by Microsoft. And of course, through a variety of antitrust actions, eventually Microsoft's control over that bottleneck was broken, and it led to 20 years of complete boom in innovation and business in Silicon Valley that we saw. I think we've reached kind of the same crossroads today with respect to mobile devices, where these two companies control everything. So they control what they can do, what they can say, how much money they can make or not make, and when they see a business that they like, they can take it if they want. And so in that way, just as we were in a place where you kind of had to get Microsoft's permission in order to succeed or fail on the internet 25 years ago, we're in the same boat today with respect to these two companies that control access to the internet, control services, and basically can pick winners and losers when it comes to business, and control and extract rents. You talked about the 30%. If they want to, they can just take a percentage of the business, which, you know, is to some degree some things that Microsoft only dreamed of doing back in the 2000s. Now the technology is such that these companies can actually do things that were only like pipe dreams for Microsoft back then.
Were you hired by Microsoft to create a monopoly or to solve a monopoly?
That's a very interesting question. The answer is both. I think I was hired by Microsoft to, you know, basically write harsh letters back to the DOJ. All right, that's why I joined the company in 2002, just as the case was settling. But eventually, you know, Microsoft kind of was forced to behave by DOJ, by the European Commission, and others. And then my job in Microsoft actually changed, because there were new businesses that Microsoft wanted to get into, and suddenly they found themselves on the other side of monopoly businesses, Google in particular, when it came to search. Microsoft was kind of a new entrant in that regard, and then my job became actually to go try to constrain Google's ability to keep Microsoft out of that business.
Well, I will take your appearance on this panel as penance for whatever ill deeds you committed while at Microsoft. Lastly, before moving to other panelists, Apple and Google will have resisted, you know, legislation like the Open App Markets Act, of course, like the Apple's the DOJ lawsuit against Apple. Of course, Google recently settled litigation with Epic Games, but there's been a lot of focus on mobile app stores around the world. And what those companies will say is, not only do we have legitimate interests in the control of these app stores for privacy and security reasons, we also built them. We invested a lot of money in them. We innovated. And if you then turn around as the government or other companies or legislators and tell us we cannot have the fruits of that innovation, what message are you sending to the market, right? So you're arguing we need to open these ecosystems for more innovation. They would say, well, we innovated, and now what? You're going to send a message that because I innovated and because I'm successful, now I get punished. You know, how do you reckon with that kind of counter argument?
Yeah, I don't think it's punishment at all, right? I think no one wants to constrain their ability to innovate and build as big a business as they want to build. But the issue really is this, and it's not that different than, you know, Microsoft made the same arguments 30 years ago when it came to Internet Explorer, and that they ought to be able to own that business too. The issue is this: and we see the pattern, I think, throughout when it comes to dominant digital platforms, and people have used different words for it: open, dominate, close, or I've called it attraction to extraction, and that the businesses, when they are in a competitive mode, and like take Apple as a perfect example, right? When they were competing hard against a lot of companies like BlackBerry and Nokia and Google and Microsoft and others for who's going to win the smartphone race, they were very open. They were welcoming developers with open arms. I know, because Microsoft often had trouble attracting those same developers. It's only when, and so they literally had the marketing tagline, "There's an app for that." So they won the phone wars by being open. It's only after they gained market power that then they decided to start to extract rents from that side of the equation. So the issue isn't to stop them from innovating. The issue is continue innovating, sell a billion more iPhones. We would love that. But they should be forced to act in a competitive space, not in one where they can, once they gain market power, then they can really change their business model to some degree and close it down.
That's that concept of being open to gain market share is something we're going to come, I think, discuss a lot on this panel. So John, coming to you, the app stores are products that people interact with all the time. The consumers are familiar with them, and sometimes when a company is the victim of what they believe is anti-competitive conduct, they go public, they complain about it, famously Tile, other, Beeper Mini, other companies. So there is some public awareness of this. Are there aspects of potential anti-competitive harm in these choke points that consumers just aren't privy to, they would never see because it's a layer of the tech stack that is not consumer facing? And do you have an example of that?
Yeah, sure. I think this is actually sort of an insidious risk when you're looking at bottlenecks for innovation. And just to sort of make sure everyone understands this open to close risk that's out there, the idea is that you create an open architecture, you invite people to come in and play, right? You allow them to design, create tools or other developments on your platform, and it sort of becomes a de facto standard for development, right? So everyone's using it, and the reason everyone's using it is because it's open. And then it creates adoption by users. It allows the platform to sort of reach economies of scale, which is very important. And it fosters dependence on the platform. So successive generations of technology are built on the same platform. And then one day the platform says, okay, this is great. Look how successful we are. What can we do with this to monetize the developments that have been made on our platform? And oftentimes they will sort of go into business for themselves in some aspect that relates to what's been developed around the standard that's been created by their open architecture, but do it in a way that closes off or gates off part of the platform itself and allows them to essentially co-opt the value that's been created on their standard. And if you're looking for things that may not be so visible to the consumer on that, it's not hard to find. We've talked about some of the app store things, some of the software developer platforms that are even visible on Meta and X. And one that is upstream is, I think, ARM Holdings. And you may not know what ARM Holdings is, but it is basically a platform on which chip developers, microprocessor developers, build their architecture for their chips. So you can kind of think of it like if you've heard of CAD design, right? There's a CAD program. You can make your CAD drawing. You can create your machine tool and then have it produced. Well, the CAD system itself doesn't tell you what to make. It doesn't design it for you, but it creates the set of instructions that allow you to design what you want. And ARM Holdings is similar to that, except for microprocessor technology. It is ubiquitously important, I think. So it is used for the architecture for chip design for almost all mobile devices, including smartphones, tablets, watches, IoT devices. And it is used on essentially all of the major chipsets that are used in handsets, including Apple's chips for iPhone and Mac, Qualcomm's chips for Snapdragon, Samsung's chips for Exynos. They all use this. And so now ARM is coming out and saying, hey, we're going to go into chip design. Okay? Is that a bad thing? No, not necessarily. But what is problematic is if in doing that, they're closing off avenues of innovation for others who are using their platform. So either reserving part of the chip design for themselves or failing to be willing to make the same access available that they used to. And I think there are a lot of parallels in antitrust law that we can find, right? It's kind of like standard essential patents, where you make a commitment to allow your patent to be used in a standard, and you have to maintain that throughout the life of the standard. But if you were to say, I'm going to make this available as part of the standard, and the standard gets adopted, and then you renege on that commitment and say, oh, I'm going to try and appropriate the value of this for myself, that would be problematic. So I think it's a pretty traditional theory that you see. It's really sort of a vertical foreclosure theory. I think it's well within the bounds of an aspen ski. It's certainly a step back from that because you're actually using the open platform to gain the dominant position in the first place. And it's something I think people do have to watch out for because you'd never see it on the consumer level.
And what are some of the potential consumer harms from these choke points that are kind of in the guts of the phone? What would a consumer be looking for if they want to find out, is this something they want their government to address? What should antitrust enforcers be looking out for to see if it's a problem? Because you said it yourself, we don't necessarily want to discourage a company that provides a platform from competing in that same market, right? So it's not a bad thing necessarily, as you argued, that ARM is going to make chips, but what would be the potential harm that you're looking for there that would be relevant to an antitrust enforcer?
Well, I think the harm is in the title of this program, right? It really is a bottleneck to innovation. What you would see as a consumer is a decline in the pace of innovation or the quality of your chips and what your phone is able to do. Would you notice it? Maybe not. You might notice it because, hey, the next version of the iPhone isn't that much of an improvement on the last version of the iPhone. Even in terms of things like how long your battery lasts, how many apps you can keep open at once, things like that, where the chip design is hugely important to those features. But to know whether the innovation has been thwarted or not, you're going to have to look at what restrictions have been put in place upstream in the design of the chips that might keep folks like Samsung and Apple and Qualcomm and others from designing a better next generation because they no longer have the entire set of the entire tool chest available to them.
Michelle, you work in the standard setting and intellectual property side of this equation, and there is often I want to say like a butterfly feeling with open source, right? There's a lot of folks in government and industry that like to promote open source. Even companies that don't really support open source will say publicly that they that they do open source because it's popular. And I think what people generally associate with that is an open platform. It leads to more competition. It leads to things being cheaper. So it would maybe not be relevant from an antitrust standpoint at first glance. It's like, oh, open source is great, right? That's how we allay a lot of the concerns that get discussed at this event. You have kind of challenged that conventional wisdom in a lot of your writing. Help us understand why the standard setting process is something that antitrust enforcers should be paying attention to, and why open source is not necessarily always good from your perspective.
Yeah, sure. Thanks for that question. So it is true, open source has tons of great benefits, but what's often overlooked is how it can be used in an anti-competitive way, in a way that could thwart innovation, sort of along the lines that John was talking about, but also in not just in the sense of creating a de facto standard, but also in the formal standard setting process. So for those of you who may not be completely familiar with that, there are standards development organizations that are based on consensus, and they have processes to help ensure that the standards that they develop are pro-competitive and will drive innovation. Things like the processes are open, they're balanced for among stakeholders, there is actually consensus voting. These SDOs also have IP policies. As John mentioned, they usually say if you contribute technology and it gets incorporated into the standard, you're going to agree to license your patents that would be infringed, essential patents, on fair, reasonable, and non-discriminatory terms and conditions. You'll hear that acronym FRAND. On the other hand, open source communities often can be more efficient, they can be more quick, they're more agile, and they're developing software under a very different process. Typically, it's a meritocracy. So those with the most resources are going to put the most into it, get to control the process, get to control the decisions. They don't actually typically have those kinds of safeguards. And more importantly, their IP policies, to the extent that they have them, generally say whatever you contribute into this code base, it's going to be free. So from an IP perspective, typically both from all forms of IP. And so what happens with open source is you can have open source being developed in standards organization to help with the adoption and testing, for example, of the standards that they develop. But what's happening more increasingly now, every year, more and more and more, we're seeing open source communities actually driving the development of standards through open source itself, through the software implementation, or the open source just is the standard, okay? There's no document says that, to comply with the standards, you have to do A, B, C, D, and you can go implement it any way you want. They just say, here's the software, this is the standard. So why is that a problem? Well, in many cases, it's not. we have like 3 scenarios: a good scenario, a bad scenario, and I'll call it the ugly scenario. The good scenarios, you have these traditional SDOs who, produce these standards, and along comes a group of companies, commercial interests, who say, we want a better standard, we want it faster, we want it to work with our products better, and they go off and they create an open source standard. And that's good, because that's going to force the standards organization, the traditional one, to say, oh, wait a minute, we don't want to be, unseated by these guys. We're going to actually make something more innovative, something better. That's a good scenario. The bad scenario is where those commercial interests who want to create this new standard say, well, we don't like that standard, not because it's not good enough, but because we have to pay patent royalties. So we just want to create a free standard, so let's do it in open source. Now, that alone might not be terrible, because that could still, make the standards organization produce maybe a better standard. But the challenge is that this open source community may just be cloning features from the actual traditional SDO. So they're just basically duplicating the standard. They're not copying the text, but they basically are saying it has feature A, B, and C, so we're going to have feature A, B, and C. That means those patent holders who've invested, maybe millions or more dollars in developing the R&D to contribute to the standards organizations still have patents that are going to cover this cloned open source standard. Now, the folks in the open source community might go out and promote it as being royalty-free, because that's how they developed it. They developed it as a royalty-free standard. But it doesn't mean that there aren't lots of patents out there that cover it. So they're promoting it, advertising it, if you will, as royalty-free, when in fact it's not. They may even know it, and they certainly don't indemnify anybody who implements that open source standard if they get sued for patent infringement. But they do that to gain adoption, and kind of like what John was saying, once they have adoption in the marketplace, widespread adoption, it makes it harder for those SDOs under the traditional consensus-based processes to compete with that. And at some point, I get concerned that the innovators who contributed to these standards in the first place are doing the hard R&D will just stop, because everything they're doing is getting cloned for royalty-free, or at least ostensibly for royalty-free purposes. So this is an area where I think in the future, we have to look at how is open source being used in standardization. Is it being used to promote competition and innovation, or is it actually being used just to unseat the innovators to have a royalty-free status quo standard? And I think those are important things to look at.
Yeah, and I want to come back to later how, what potential scrutiny would look like if it's appropriate, and whether the other panelists agree. Taylor, we heard your chairman mention a couple of big cases, and I've seen enough panels with government officials to hopefully not ask questions where the answer will be, that is a pending case and I can't comment. But the FTC has major cases still ongoing. One is on Amazon, which will go to trial, I believe, in 2027, February. And then, of course, you mentioned, the Chairman Ferguson mentioned the appeal of the Meta. Let's start with Amazon, because I mentioned at the beginning in my intro that there are certain things you need to be a successful innovator and entrepreneur in technology. It's not impossible to succeed without being on Amazon.com as a retailer, but it's certainly challenging. And the FTC has alleged self-preferencing and excessive fees, up to 50% of sellers' revenue as part of the allegations in that case. How do you view that case, both from a consumer welfare standard? Of course, price is the obvious problem with consumer welfare if people are paying more from goods, but also, is the FTC looking at the potential harms to innovation that come from that bottleneck that the agency alleges that Amazon has over e-commerce?
Yeah, thank you so much for that question. And before I answer it, thanks to the Bull Moose Project for setting all this up. And Aidan, really appreciate the opportunity to be here and speak on this panel. And then I will give the standard federal government in disclaimer. I share today my own views, not those of the commission necessarily, or certainly any individual commissioner. I think, as you said, there are many analogs between some of the other tech sectors that folks have talked about. If you were trying to sell an app, right, you basically need to go through the App Store or the Google Play Store. If you are selling a physical product, it is astounding the percentage of online commerce that goes through Amazon.com, whether in the first-party retail perspective or the third-party marketplace side. And so it's certainly a case that is extremely important that the Commission takes very seriously. And while I can't give specifics, I can say it is an exemplar of why the Commission cares so deeply about innovation bottlenecks. Technology is a field that is extremely rife to have early leaders obtain and cement tremendous percentages of any given market very quickly. So think about the iPhone, what they call Facebook Blue, the original Facebook app involved in the Meta litigation, Google Search, Amazon.com. You see kind of time and time again, these early leaders in a space maintain enormous market shares for enormous periods of time. And so there's always a danger in these kind of fast-moving innovation markets that an established market leader could engage in conduct that stifles competition. And when you look at these huge tech products, the consequences of any kind of stifling of innovation in those spaces are enormous. Enormous amounts of commerce go through these spaces. Enormous amounts of consumer interest are predicated on the specific policies of an app store or of an Amazon.com. So as a descriptive matter, I don't think it's a surprise at all that across administrations and carrying through to the Trump-Vance FTC, we've seen a lot of different major monopolization cases in the tech sector. And I'll add maybe just a little different spin on it. The Meta litigation obviously involved mergers and acquisitions, but in tech and similar other kind of medical devices, other technological fields, mergers and acquisitions can really serve as a bottleneck to innovation. So the FTC has a couple recent wins in it. It's a trial between two companies, or against two companies, Edwards and Yenivelv, and a second abandonment announced earlier this week of a merger between Elcon and Lenzar. These were both, broadly speaking, medical device proposed mergers that the FTC blocked. And in each case, the acquisition threatened to basically rob American patients of competition that was driving innovation. And allowing one company to kind of bottle up all of the innovation in one space in these medical device fields would absolutely create a bottleneck and stifle innovation. And you can draw any analogies that you wish to tech and some of the FTC's tech cases from that example.
One of the criticisms of the, let's say, the bipartisan neoliberal consensus from about 1980 to 2015, right, like give or take, was that it was hyper-focused on consumer welfare only as a price matter, and if there was not an obvious price gouging, like Standard Oil type behavior, that antitrust was essentially not needed or relevant. And I think we saw across the first Trump administration to the Biden administration and continuing with this administration a more expansive definition of consumer welfare that includes things like lack of choice or other potential harms. One of the areas that the FTC has talked about in the context of the Meta litigation is privacy and how the potential impact on, I guess, lack of privacy preserving options or the inability of privacy preserving options in social networking or otherwise to flourish in the tech ecosystem. The FTC has done a lot on children's safety and children's privacy. You, of course, write the rules for children's online privacy and enforce that statute. How is the FTC thinking about the intersection between antitrust and privacy as a potential consumer welfare issue?
Yeah, I mean, so I think where you kind of began this question is price the kind of be-all, end-all of competition policy? And the answer to that is emphatically no. Competition can play out in a wide variety of different facets and markets, and the idea that we should be singularly focused on price as the be-all, end-all is just wrong. Congress did not provide as much in the Sherman Antitrust Act, the Clayton Antitrust Act, the FTC Act, where I spend most of my time. It would have been very easy for Congress to limit those statutes to price. It didn't do so, and I think we're obligated to think about competition in all facets accordingly. Candidly, I find much of the defense bar's like obsessive focus on price to be transparently strategic. They think it's difficult for the antitrust agencies or kind of individual. I was a mostly plaintiff side attorney prior to this. They think it's difficult to prove price effects, and so that's the standard they want to set. For the agencies to meet in any merger litigation, or you think about The Meta case or Google search case where we have kind of functionally zero price or nominally zero price products. So that's why everything's about price is just a defense kind of ploy to try and win cases. And then the irony is on another case right now I'm dealing with where we have basically indisputable price evidence. The defense bar comes to me and says, oh, Taylor, ignore all of the price evidence. You got us there, but it's really about quantity. If you can't show, people are getting gouged on price, but you can't show that quantity will change, like you have nothing. So I put very little stock in that. The better answer, I think, is that competition, consumer harm to American workers can be felt across numerous dimensions. I think, Evan, you mentioned privacy, which is an incredibly important one and one that featured in our Meta litigation. I'll give another example that's a little easier to talk about because it's concluded and obviously Meta is still on appeal. But the FTC recently obtained a divestiture of more than 100 different facilities in a case called Savita Brightspring. And this was the merger of two different companies that ran basically homes for people with intellectual and developmental disabilities. So this is folks with IDD is kind of the shorthand. This is a market where prices were effectively set by state Medicaid agencies. So there was no price competition, period, between the merging firms. And that did not stop the FTC from aggressively reviewing and pursuing the transaction and ultimately obtaining divestiture of more than 100 different facilities. And you can go look at that complaint, but as the commission described there are critical aspects of competition that play out in quality. In the Meta case, it might be privacy. Here, it would be the quality of care provided to some of the most vulnerable Americans. And so next time, a defense bar comes and says, oh, well, competition can only play out in price, I would direct them to the victims and the individuals who suffer with IADD, to their families, to the patient advocacy groups. And they will tell you that quality and non-price harms matters and really affect their day-to-day lives. And then finally, kind of one more callback to the Meta case. I think it is very safe for me to say the commission presented gobs of evidence about harms to quality on Meta's apps. And so there was evidence of increased ad loads and the kind of uncontroversial proposition that consumers don't like watching ads was even contested by defense in that case. There were worse privacy protections, a lack of investment in the core kind of friends and family products, which is an element of innovation and innovation competition. So competition, it is my firm view, drives improvements in all dimensions, not just pricing.
John, you've been on the side of representing companies that are facing antitrust scrutiny from the FTC, DOJ, international regulators, but you also clearly, based on my first question to you, you do see a role for scrutiny where it should be applied. One of the critiques of the monopolization cases against big tech is, setting aside the merits, they just take too long. Right, we've seen cases get filed in 2020, 2021, 2022, and then they take 4 to 6 years to get a decision. Then you have another year after a liability is found to get a remedy, and then by the time the remedy is written, someone says, well, there's ChatGPT now, so you don't have to do anything. Right, I'm being flippant, but now TikTok exists and you changed your business model, and so that's why, right, Meta wins. And I'm being flippant, but like, setting aside that, do you think that antitrust law is capable of keeping up with digital markets when a case takes 4 to 6 years? Is this an argument for either legislation or for judges to say, I'm going to kind of freeze the market in time and only look at the harm that happened 4 to 6 years ago to avoid, having to decide something different based on something changing? Or does that just prove the point of many critics of this organization, I guess, in this project that we're talking about today, where if a judge has to, if the judge takes 6 years and says a change in the market means that you're no longer dominant, doesn't that prove that you were never really that dominant? I guess many different questions there, but if I had to make it one question, I would say, do you believe that antitrust law is fit for digital markets? Would you make any changes?
So I wouldn't disagree with you that antitrust cases take too long, right? And I do think there is scope for, in the judicial process especially, to look at ways to expedite antitrust cases. I think that's important. I think that's a separate question from whether we need some new legislation to address the digital economy. Look, innovation is the lifeblood of the U.S. economy. true innovation leads to market power, right? That's not necessarily a bad thing. If you do something truly unique and it's incredibly productive and of value, there's going to be at least some period of time where you should be able to capture that value, right? When you're talking about bringing monopolization cases, one of the questions is, in whether someone is a monopolist or not, is that market power durable? And if it's not durable, then you're not really a monopolist, right? So part of the question is, when you have an innovation, how big is your head start? Another part of the question is, when you have that head start, what can you do to keep others from catching up? And I think the cases need to focus on the devices used to keep others from catching up, right? That's the exclusionary conduct. But I do not think it's appropriate to say, well, because we have this system where innovation leads to market power, that we need to legislate it in advance. I think that's a disastrous conclusion, because I've never seen, ever, a piece of legislation that has catapulted innovation forward. And if we have to choose between trying to catch innovation before it starts and make sure it doesn't get out of control, or trying to catch the exclusionary conduct once it's happened, every time I would choose catch the exclusionary conduct. Can we do a better job of it? Yes. Should we look at ways to do a better job of it? Yes. I'm actually sort of a fan of the European Commission's use of interim measures in these cases, right? It's a way in which it's kind of like injunctive relief that they get up front, or a TRO they impose themselves. It's a way for them to say, hey, we have a market where we think someone's exercising market power, and rather than wait till the end of our case to do something about it, we're going to put in a measure now that actually is a preemptive remedy in some ways, that at least will keep the separation between the parties no greater than it is now. I think that's one example of, in certain cases where it's justified, a tool you can use that, in my opinion, is a lot better than, for example, the Digital Markets Act, which, when I look at that and say, how has that helped innovation in Europe, my answer to that is not at all. So there are a few thoughts for you.
Michelle, you talked about, when we were prepping for this panel, how there's not necessarily any attention from antitrust enforcers on the potential collusive impact of the standard setting process that you were talking about, or the open sourcing. You've also talked about not enough attention being paid to business model competition versus just number of competitors in a market. Are these things that you think antitrust enforcers should just organically take a look at? Are there pieces of legislation you'd like to see passed to draw attention to these issues that you've written about?
Sure. Well, I think there is a lot of attention paid to standard setting. That's been around for a long time, and particularly the IP issues and the process issues and standard setting, which the open source piece of this, I think, hasn't received a lot of attention. Going back to your earlier question, most people say, hey, what's the problem with open source? It's great. Everybody loves it. It's free. Everybody can use it. It's wonderful. But the problem with open source is, if you look at who is actually developing, I mean, decades ago it started up with hobbyists. Okay, but now it's a commercial activity. The participants developing the open source projects are, by and large commercial entities, and they use it in a commercial way to derive value from their other products, their services, whether that's strictly by upselling those or just by getting more people to their platforms, as some of the others on this panel have talked about. And so I think people have to understand that the use of open source is, in fact, a business model. And so I sometimes divide the world into, this is a little bit overly simplistic, but in the standards world, we have a handful of companies that invest lots and lots of money in developing really challenging technical solutions for infrastructure. And they do that with the intent to contribute it into standards development, and the way that they make money from sharing that IP is through licensing their patents on those fair, reasonable, non-discriminatory terms and conditions. I call those folks standards innovators. Then you have many, many, many more companies who I call product innovators, because they're still very innovative. They spend lots of money on R&D, and they make very innovative products and services. but they have no intent of sharing their intellectual property with their competitors. They want to keep that proprietary so that their products have a leg up. They're differentiated. And they want to use that infrastructure, those standards, as cheaply as possible, because that's not where they make their money. So they want to consume that IP, and they want to keep their own proprietary IP proprietary and differentiating. And so you have these two business models that compete, and I think it's really important. Most people don't pay attention to that. They say, well, I don't understand, why do these big companies, why are they okay about licensing their patents for standards essential free, and these other companies who are innovators say, no, we want a return on investment? I say, well, it's because you have to look at their business models. How do they, and if they're supporting open source, then you have to look at how are they monetizing their efforts in open source. And so I do think that as we move into this world where standards are now being either driven or dictated by open source, I'm not saying in every instance it's going to be anti-competitive or thwart innovation, but I do think that we need some guidance on where those lines are. There are lots of situations over the past several years where there have been people who have identified areas where, hey, this is an anti-competitive use of open source. Whether it is or not, I don't know, but I sometimes represent some of these communities, both open source communities and the standards organizations. And I don't know that legislation would be appropriate at this point, because I think all of these situations are very, very fact-specific. But I sure would love to see, in my perfect world, I would love for the Department of Justice and the FTC to maybe update their 2017 guidelines on licensing of IP and address some of these situations so that we would know when we might be crossing a red line.
Well, if only there was someone here who could take that
Help me with
recommendation
that.
up. So, Gene, I imagine you might have some thoughts on legislation that differ from John's.
Yeah, I was going to say, I have a different perspective on legislation. I've been a strong proponent of kind of the move for new legislation in the digital space over the last 5 or 6 years. My clients have a keen interest in it. And I think it's because when it comes to digital platforms, those monopolies actually are a little different than what we've seen. We're here at a Bull Moose event, and our original trust buster, Teddy Roosevelt, faced people like John Rockefeller in oil, or Andrew Carnegie in steel. But what those monopolies could extract monopoly rents. They could charge and control output. They could charge monopoly prices and control outputs in their respective markets. But what they couldn't do was be a bottleneck on innovation. It's like Andrew Carnegie wanted lots of railroads built, right? He loved innovation in railroads or airplanes or whatever the case may be. And same with John Rockefeller, wanted oil used to the maximum it could be. So innovation on the oil platform was in his interest. What we've got today are monopolies, and durable ones. I mean, if you think about how antitrust has applied itself to these digital platforms, kind of the seminal case 25 years ago is US versus Microsoft, right? And what people debate whether that case was successful or failed, but you can't deny that 25 years later, Microsoft still has a dominant position in desktop operating systems, the monopoly that was tried to be addressed 25 years ago. But what that case did do was prevent Microsoft from exercising its market power in a way that discouraged or prevented innovation on that platform. The failure of the antitrust case, however, was that it's very fact-specific, and every digital monopoly platform says, well, that doesn't apply to me, and they kind of operate for a decade or more in kind of with impunity almost to kind of exercise their market power in anti-competitive ways. And we've seen that with Google, we've seen that with Apple, where they now have durable monopolies that prevent innovation on their platforms. That's why I think this wave of new legislation is kind of necessary to say, no, the rules that tried to be established by the DOJ in the Microsoft case actually do apply to you, and they apply to you in these ways. They don't prevent you from improving your phones and selling as many phones as you want, but they do prevent you from exercising that market power to either extract rents from people that are building on your platform or excluding that kind of competition on the platform. And I think legislation will have an effect of kind of short-circuiting that decade or two of the exercise of market power to the detriment of business and consumers, and allow them to, continue to build their platform in the best possible way that they can, but prevent them from engaging in those kind of obvious foreclosing behaviors that we've seen. And I think things like the Open App Markets Act in the United States, certain aspects, not all of them, of the Digital Markets Act, and I think the only reason it hasn't had a positive impact yet in Europe is it hasn't been enforced yet by the European Commission. They're kind of deciding how best to take those steps. But I think the digital platforms are kind of fundamentally different in that they not only impact price and output in the mobile phone space, they impact all the downstream markets.
Taylor, one of the issues that the FTC has looked at across administrations is the tremendous amount of acquisitions of large technology companies by startups. And maybe that's one of the challenges for antitrust enforcers is when startups that have little to zero market share are being acquired. From a traditional antitrust lens, you might look at that and say, well, were the two companies competing? No, because one of them has zero market share. Why is this a problem? And we've seen a spate in recent years of what has been described in the tech press and the agency and others as like acqui-hires, where large tech companies that are maybe under antitrust scrutiny don't want to buy companies outright because that might trigger some reviews, so they hire everyone that works at the company, license the IP, and then leave behind like a zombie of that old company that maybe continues to exist, maybe doesn't do much. I know the FTC's looking at this. Is this an aspect where technology poses unique challenges? Gene mentioned how it's maybe poses unique challenges to antitrust that oil and railroads didn't. How is the agency thinking about acquisitions of startups as a potential bottleneck to innovation?
Yeah, and so there's a number of different questions embedded there, and I'll try and...
I'm famous for asking like 7 questions in
No, that's
one,
good.
so thank you for...
Let's talk for 7 minutes without interruption.
Thank you for bearing with me.
I mean, my basic view, and I don't have a particular position on any potential legislation, of course, but the antitrust laws have really sustained the test of time. We have more than 100 years of history behind the Clayton Act and the Sherman Antitrust Act, and they have adapted to technological innovations and challenges along the way. So I have tremendous faith that they will do so yet again in every new wave of technology. But I hear on a weekly basis, if not more, the argument that some big company is buying a small competitor, but this is really, really good and pro-American because they have the super mega awesome platform for acceleration of this new small company's technology. They even give them names like hypersonic scale, like it's comical. Perhaps that's true sometimes, and we obviously take that argument very seriously because we don't want to obviously get in the way of a pro-competitive deal. But it's often not true. Often that argument is just there to mask kind of blatantly anti-competitive deals. Earlier I described the Edwards, Yenivelv, and Elcon Lanzar cases. I think these are both good examples where a very large established player in a space was trying to buy kind of an upstart competitor. And the commission took the position successfully that both of those would have been very damaging to innovation and competition. So the moral of the story there is I think we shouldn't be complacent and just accept that the American economy should have a few big tech firms and a few big medical device firms and a few big AI companies, and that's the best it can be. Those firms started in garages and in Meta's case, I suppose, a dorm room. And there's no reason to put a ceiling on how amazing the next wave of garage and dorm room innovators could be. And we can have bigger dreams for them, and they can have bigger dreams for themselves than just to be bought out by Google after they have 3 years of track record or whatever it is. Another question is, when those deals come, how do we evaluate them? The answer there is perhaps a little less exciting, which is using the 2023 merger guidelines and our traditional rules of antitrust review. But one of the questions there is really, some of these deals are sub-HSR, some of these deals are structured to avoid HSR review, but the HSR Act is a procedural safeguard. It's a really, really important one, and it's one that I care about a lot, but we do not need an HSR filing to make an attempt to block a deal or to file litigation. An example I will give of that is there was a extremely well publicized attempt by Novo Nordisk, which is one of the GLP-1 giants, to buy a company called Metsera somewhat recently, which had a very innovative kind of future GLP-1 space drug. Novo Nordisk was attempting to make that acquisition for $11 billion or thereabouts, and structuring it so that I think $8 billion of that money would have gone to shareholders as an immediate dividend prior to an HSR filing. We were willing to be extremely aggressive in that circumstance, make sure the parties knew exactly our ability to seek an injunction to prevent those money flows prior to any attempt to evade HSR review. And the history books and the Novo Nordisk press releases suggest that we were successful in that attempt and stopping that potentially seriously anti-competitive non-HSR transaction. And I think that's a reasonable pivot to the kind of third embedded question there, which was about these acqui-hires. And really, the deal structure you described, I think people will say, is a reverse acqui-hire, because acqui-hire would be too simple. We've seen a number of these deals recently. They're becoming more popular, and there's some kind of prevalent theme that Silicon Valley has cracked the code on HSR review, and they're never going to get HSR review again. My response to that is basically hogwash. So the Clayton Act and the HSR Act cover acquisitions of assets. The question is whether these reverse acqui-hire transactions transact assets. Okay, and so we have these potentially multi-billion-dollar deals that involve a company acquiring the rights to what some folks would call human capital. We have the rights to loads of trade secrets, the rights to intellectual property, the rights to work in progress, and so on and so forth. So I actually think it would be extremely difficult for these HSR practitioners or antitrust counsel to get in front of a federal judge, look them in the eye, and say, Your Honor, it's a trick question. We didn't buy anything in this multi-billion-dollar transaction. Now, to my knowledge, no federal judge has assessed that question. It has not been litigated. But I think the prevailing, and speaking again only for myself here, I think the prevailing wisdom in the antitrust practitioner community that this is some kind of fail-proof cheat code to evade HSR review is wrong, and folks should be advising clients that it is a path that's undertaken with some HSR risk.
No get out of HSR jail free card. Yeah. Thank you for answering a 7-part question in 3 parts. That's a good fraction there. John, something you said earlier stuck with me, so I'm going to ask you about it. You talked about how, of course, when firms innovate and they develop a dominant position, that's not necessarily a bad thing, right? Because we want to incentivize these very popular innovations. And for a lot of people in DC and in private practice who are skeptical of this, increase in antitrust enforcement, one of their critiques is this is all just kind of vibes, right? You're all just deciding when something's okay and when something's not, right? And one could maybe look at this ecosystem and see who gets to decide what the correct amount of fruits of the innovation is before something needs to be opened up, right? Or before, the injunction option you mentioned earlier gets to be on the table, or before legislation needs to come in to say, yes, you can run your app store, but you can't use the app review process to copy someone's app and then release it and then kick them off the store and say it's for cybersecurity, right? But a lot of this is just trying to decide the balance, right, between you can make a certain amount of money, you can develop a certain market share. That's all good. We support that. It's pro-competitive. And then we have to decide when that turns. And is there a kind of foolproof guiding principle here, or is this really just what makes antitrust complicated? Is that we're trying to decide what that balance is, and how do you, as a practitioner, how do you know when the line has been crossed? Maybe a company sues, maybe an agency sued, but how do you know, and how do you think people should know when you've had enough and it's time to open up your platform to others, for example?
So I use a Ouija board. Now, look, the approach that is taken to most of these cases is a rule of reason approach under the law, right? Which means you don't automatically know, right? Short of price fixing, bid rigging, those kinds of things that it's always bad. Here you don't always know it's bad, but you can look for certain indicia of whether there's a problem or not a problem. I don't have a complete list, right? I don't have the answers to all this. I can't tell you, here's when you push the button and say this is an antitrust violation. I will say in a general sense, relying on repeat innovation in a field is very important. And so if you're looking for indicia, you look for indicia that would prevent the repetition of innovation in that field. I completely understand why Gene, given his constituency, says, yes, we should have legislation, right? Because where you have a market that's already developed and evolved, and if there's an exploitation of market power in that field, legislation can be effective to prevent that. But there's a consequence to generalized legislation that relates to the technology world that also risks inhibiting innovation and repeat innovation. If I'm looking for certain indicia, you look at the conduct of the dominant firm, and you might ask yourself, okay, if they're putting in restrictions, has there been some change in circumstance that's led to them putting these restrictions? If privacy is the justification for changing access to your APIs, is that privacy concern new, or was it there when they set up the structure? Look at whether the restriction is going to adversely impact not the innovation of the dominant company, but the innovation of others trying to compete against the dominant company. I think competition for innovation is incredibly important. And I will refer back to the ARM situation where ARM entering into the production of chipsets is not necessarily bad unless it inhibits the innovation of the others, because that competition for innovation on the ARM platform is incredibly important. You could ask the question, is the dominant firm imposing restrictions that reserve some portion of the advantage on the platform to itself, right? Are they sort of cordoning off, putting a red rope there and saying, well, we'll let all of our ideas into the club, but we're not going to let all of other people's ideas into the club, only if you're really pretty. And as a last one, again, is it an attempt to actually add incremental value through the innovation of the dominant firm, or is it an attempt to appropriate the value created by others? I don't have all the answers. There are some indicia you can look at. I'm sure there are lots more, and I think this is something that should be examined and written on more than it has been.
Michelle, how do you think about the way to determine when that line's been crossed, especially because you work in an area where you said in your answers that there really isn't much scrutiny or attention, at least as you argue. So if there's not much scrutiny, it might be hard for anyone to spot when that line has been crossed, according to your concerns.
Yeah, so I like the Ouija board.
Or like a smoke
and
signal.
that's pretty much why I said, it would be really helpful to have some guidance, because when you are advising these communities, whether they're developing standards or open source or a combination of those things, you want to make sure that what they are doing is in fact pro-competitive and doesn't cross that line. For me, there's a couple obvious cases where I wouldn't say without other facts and circumstances, but there's certain things that raise flags. For example, in the standards context, if you have an open source standard, meaning that is the implementation, and that everybody is adopting that implementation, there's not a lot of competition among implementations. And let me just explain that a little further. So with a standard is actually a document, and it says, to comply with this standard, you have to do A, B, and C. And everybody can go off and do it their own way. Some can, make it really good and really fast or whatever, and some can say, well, we can do a low-end one as long as it works. But they can all differentiate their implementations and compete in their products with their standards-compliant implementation. If you develop an open source implementation and it's the only implementation, then you're not getting that competition. So for me, that doesn't in and of itself mean it's anti-competitive, but that would be, for example, a red flag. There are other areas where if you basically, there are, for example, a lot of the standards organizations, traditional ones, have these FRAND-based policies. And they have, over the decades, become the main place to do certain kinds of standards. Think about ETSI for telecom standards or 3GPP. Think about the IEEE for Wi-Fi standards. if they suddenly changed their policy, their IP policy after all these years, it would be really hard for someone who didn't like the new policy to go someplace else and try and, work with others to develop a new standard.
Build your own Wi-Fi.
Exactly. It would be really hard to do it, for example, without the IEEE. So now if you have a bunch of competitors who do not like paying patent royalties, say, hey, even though you have a friendly patent policy, but let's do open source instead. And that requires everybody who's going to participate in this process to do so on a royalty-free basis. You are, in effect, changing their longstanding patent policy. And so entities that had participated for decades helping to build this standards body as sort of the place to go for that type of standard, now they can no longer participate in those standards efforts. They can't contribute because it goes against their business model, because they'd have to give away all of the work that they invested in royalty-free, and that's not their business model. But their competitors have, come in. So for me, if that was the case, that would say to me, hey, we should look at this. Again, I'm not saying that in and of itself is a problem. The other one is when we do have these competitors who go off and say, hey, we want a royalty-free standard, so we're going to just do something on the side in an open source community. And now we've basically cloned the royalty-bearing standard, but we're going to advertise it as royalty-free to increase adoption. That would also make me think of, gee, maybe this is something we should look at. That's a flag.
All right, we've got the yellow light here, which means we are low on time, so I want to move to closing thoughts. We've got an AI panel after this, so if you want to tee something up for that, or just anything that the antitrust enforcers in the room or policymakers or journalists should be paying attention to, I'll start with you, Taylor.
Well, most of what I know that the antitrust enforcers are paying attention to is non-public, so I can't share it. So I will say simply...
You promised me a list of companies that were under investigation. You promised it to me.
Exactly. I'll give that to you separately for your Polymarket account, or Bullshit, or whatever you use.
I'll see you at the bar.
It's a joke. No, I mean, I am extraordinarily blessed to have a very fun job where the ideas I have for how antitrust enforcement could be better, there's a whole team of marvelous attorneys I can ask to go investigate and implement those ideas. And so I will say simply stay tuned. We have an amazing team at the FTC. I'm just one of many great folks there, led by Chairman Ferguson. And I think folks in this room will be very excited about the developments coming out in the months to follow.
Thank you. Gene.
So you mentioned AI, and it was earlier mentioned this Apple ban on vibe coding apps and what that means. I think it's indicative. You talked about what are the indicia of a problem emerging, and I do think it is this idea of a change in fundamental business practices that coincides with the achievement of market power. So you think back years ago, it was Microsoft that was successful with Windows because they were open to developers. There's a video of sweaty Steve Ballmer on YouTube where he's chanting developers, 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 until Netscape came along, and then it was like, well, not that developer, right? And we have the same thing with Apple, where it was, there's an app for that. Only now, all of a sudden, it's like, well, there's not an app for vibe coding, and there's our app for music streaming. And so it is that change in business conduct that I think we've seen. And so and these platforms are essential to allowing innovators to get to their customers, and when they get locked down, then you start to see the problem in innovation.
John.
Maybe just a momentary defense of the defense bar. Look, I've represented platform companies. I've also been adverse to platform companies probably an equal number of times. I'm not a fan or going to defend the abuse of a dominant position or the exercise of market power. But I am a fan of innovation, and having seen behind the scenes and understanding the business objectives of a lot of these actions, you can't make presumptions. You can't presume that a reverse acqui-hire is designed to avoid antitrust scrutiny. I mean, you have to look underneath and see if there's a real antitrust problem. If there is, absolutely the agency should go through it, but you can't make a presumption. I think that's true of almost everything we've talked about today, that you can't make a presumption. You've got to look behind the scenes. You mentioned price effects. I think the defense bar, in its heart of hearts, if it has a heart, would not suggest that price effects are the only effect. I mean, look, you can go back to the Muris administration and before that, and innovation has been a watchword as a competitive harm for a long time. I think that needs to be the case. It should still be the case. And when there is harmed innovation, that the agency should act. We do need to find a way to act faster.
Michelle, 30 seconds.
Okay, I don't know about 30 seconds, but I'll go fast. So you brought up AI. I think, I only had a chance to talk about concerns about open source as a bottleneck in the context of standards, but I also see it as a real issue in AI. The current administration put out the America's AI Action Plan last July, and 2 goals, keep our technological leadership and promote innovation. And I found it really unbelievable that I didn't see anything about intellectual property with those 2 goals in mind. But there was just a couple sentences given to open source. We should promote open source and open weight AI. Without any kind of definition of what they meant by that, it could be interpreted as make it completely open to the public, completely free, no restrictions. And I just don't understand how we would, if that was the case, and I don't know what it was, but if that's the case, I don't understand how we would expect all these US companies to invest billions of dollars in developing AI just to give it all away openly for free. I think we have to really take a look at business models and understand licensing of IP is an important aspect of promoting innovation and competition. And don't just default to this open source because it sounds good.
I think for now, Sam Altman's going to make sure we do pay for it. But thank you all for joining. This was a really great discussion. I appreciate it. Thank you.